Good afternoon. I'm Kristen Savell, one of the managing directors of the Rock Center for Corporate Governance at Stanford University. I want to thank you for joining us today for the Rock Center Lunch Talk on whistleblowers, ethics, and compliance. I'm going to quickly go over a few housekeeping matters and then we will get started. So first, we will be offering 1 hour of California MCLE credit for today's session. A link to the MCLE form will be pasted in the chat box, so please look out for that. We will be recording this session and we will make it available on our website in another week. If you want to watch it again or if you want to share the video with your colleagues. Finally, we encourage you to ask questions, but please do so in the Q&A box and not in the chat box. I will be handling audience Q&A at the end of the session. Okay, we have an exceptional lineup of speakers for you today. Robert Chestnut is the former Chief Ethics Officer of Airbnb and author of a new book called Intentional Integrity: How Smart Companies Can Lead an Ethical Revolution. Erica Chung is co-founder and executive director of Ethics and Entrepreneurship. You may know her as one of the key whistleblowers who reported biotech startup Theranos to health regulators. Mary Inman is partner at the law firm Constantine Cannon. After 20 plus years representing whistleblowers in the US, she moved to London in 2017 to launch the firm's international whistleblower practice. Steve Pekin is a partner at Sullivan & Cromwell and former co-director of the SEC's Division of Enforcement, where he and his colleagues worked to, among other things, streamline and accelerate the evaluation of whistleblower claims. Today's session will be moderated by Joe Grunfest, the W.A. Franke Professor of Law and Business and Senior Faculty of the Rock Center for Corporate Governance at Stanford Law School and former Commissioner of the SEC. Joe, I'll turn it over to you.
Kristen, thank you so very much. And I'd very much like to thank all of our panelists and everyone who's joining us online for this session. We really do have a remarkable collection of talent over here. Hard to think of anybody that would be more experienced than the group that we have. Let me sort of, frame the conversation that we're about to have by explaining that earlier this week, for the first time in my life, I got a phone call from someone, and the first thing they said to me is, Joe, when I grow up, I want to be a whistleblower. All right, that you never used to be a career objective. When I grew up, I want to be a fireman, I want to be an astronaut, what have you. Why did someone say to me, gee, I want to go up and be a whistleblower? They heard about the largest whistleblower award that the SEC had ever issued, and that was for $114 million. It's a lot of money. It's a lot of money even on Wall Street, and that's the amount of money that somebody actually made by taking information about a violation of the federal securities laws and, in effect, picking up the phone or having a lawyer pick up the phone and pass that information on to the Securities and Exchange Commission. Some interesting statistics will help frame how large this phenomenon is, how large it might become in the future, and what I think are the very serious implications for just about every corporation that's in the business of that issues securities and what have you, because exposure under this law is not limited to publicly traded corporations. It affects publicly traded corporations and every privately held corporation in Silicon Valley and the like, as Ms. Chung's experience will also help us understand. So in total, the Securities and Exchange Commission has given out more than $700 million in awards to whistleblowers. The top 10 awards to whistleblowers constitute $430 million. So approximately 61% of the total amount of awards that the SEC has issued has gone to 10 mega awards, and the 10th largest award was for $22 million. So if you want to stop it, if you want to think about it, there are 10 whistleblowers that have received $22 million or more, and the largest whistleblower award to date is $114 million. These are not trivial sums. These are major financial incentives for people to step forward and tell the United States government about violations of federal securities laws. Steve, you've been at the belly of the beast. You're recently out of the Securities Exchange Commission. You had senior responsibility for overseeing and operating this entire mechanism. What can you tell us about the program, about how the program works, how the SEC evaluates their claims, the statistics associated with the operation of the program, and observations about where it might lead in the future.
So thanks, Joe, and thanks for including me in this program. So I think the SEC's whistleblower program, which is obviously enacted as part of Dodd-Frank and is now, I think, entering its 8th or 9th year of operation, has really been transformative for the SEC's enforcement program. And the program has, just sort of been to some degree a victim of its own successes, as its popularity and the numbers have, sort of exploded. So just to give you a sense of how it works, I think of it in two pieces. So the first is, how do you triage and evaluate claims that come in from whistleblowers? And then secondly, how does the commission evaluate and adjudicate claims for payments of awards when there's been a successful action? So the first part is pretty straightforward. The SEC has in place a rigid process and protocol for evaluating all tips, complaints, and referrals that come in. Those are triaged by the SEC Division of Enforcement's Office of Market Intelligence. And there's an effort, I think, to review every one of those tips, complaints, and referrals, including whistleblower tips, within, I think, 48 or 72 hours. So a human being looks at them and makes a determination as to whether this is something that, should be referred for further inquiry, closed without action, or supports opening an investigation. And to give you a sense of the volume of that, I think in fiscal year 2020, there were 24,000 tips, complaints, and referrals. And I think over 6,900 of them came from whistleblowers. And that 6,900 number, I think, is more than double the number of whistleblower claims that came in the first year. So evaluating whistleblower claims is really folded into the process for evaluating all kinds of tips, complaints, and referrals that come from, victims, from, other law enforcement, from self-regulatory organizations and the like. So then the investigative staff will work with whistleblowers, and many of whistleblower tips, they obviously have a range. Some of them are highly meritorious, and some of them are not. In particular, I think we have a pretty sophisticated plaintiff's bar that has grown up and is very astute at identifying potentially meritorious whistleblower claims and packaging them and presenting them in a way that they are attractive for enforcement investigators to investigate and pursue. And many of the largest awards have sort of followed that path where whistleblowers are represented by sophisticated counsel. So that's on the front end and during the investigation, and then fast forward to if the SEC has a successful action which results in the recovery of $1 million or more, the SEC will then note to the world that there is a potentially covered action that anybody who believes they're entitled to a whistleblower award from can make a claim against. And they're eligible, if they're meritorious, for 10 to 30% of the total monetary award that's collected. And as Joe, as you noted, some of the times, given the size of some SEC, disgorgement and penalty figures, that number can grow, quite large. I think, one of the things that my co-director, Stephanie Avakian, and I spent a lot of time on was trying to increase the efficiency of the process on the back end. So the process, without, expending too much of our valuable time here, there's a notice that's given out to the world that says, here is a successful action that a whistleblower might be eligible to claim against. Potential claimants then make submissions claiming entitlement, explaining, the information that they provide and why they believe they're entitled to an award. The SEC's Office of Whistleblower evaluates those, works with the investigative staff to verify them or not verify them, and then makes a recommendation as to whether an award should be made and in what percentage. That recommendation is initially made to what's called the claims review staff, which is a body comprised of about a half a dozen senior officers of the enforcement division. I sat on the claims review staff. And then working with the Office of General Counsel, there's a determination as to whether to accept the Office of the Whistleblower's recommendation or make a determination different. All of those determinations are ultimately subject to review by the commission, which has the final determination as to how much of an award to make, either on an aggregate amount or on a percentage basis. So that's kind of an overview of the program. One of the things that we worked really hard on was to try to reduce the backlog of outstanding whistleblower claims for awards, increase the efficiency of adjudicating those. So I think that the program has been burdened by sort of frivolous serial filers, people who lay claim to a portion of the award for every single, literally every single notice of covered action that is out there. And that has sort of served as kind of an albatross or an anchor on the program's processing. We put in place a number of protocols to sort of make determinations of both meritorious and non-meritorious claims much easier. And I think if you follow the work of the commission, you've seen over the last 6 months or so that efficiency process bearing fruit, because the pace at which awards are being made has ramped up geometrically. They're just much faster, and I think the backlog is being worked out. So I'll pause there.
So Steve, let me just ask you a question, sort of calibrate the significance of this phenomenon to the SEC. If you take the SEC's total enforcement deal flow over the most recent 12-month period, what percentage of that, in terms of penalties awarded, do you think is attributable to the whistleblower program?
Yeah, that's knowable. I don't know the answer to that question, Joe. I don't think it is an outsize, portion. If the SEC brings on average about, sort of 500 substantive cases a year, I think the whistleblowers are responsible for still a fairly small percentage of those.
But what if we look at the dollar amounts? What if we count dollars, not noses?
So, I mean, I think it really, it varies. There can be very, very large awards, or rather, cases that result in very, very large monetary resolutions that don't have the involvement of whistleblowers. Those cases can be sourced from all kinds of different places. I don't know if you look at, I think in the recent rulemaking, the commission said that, very, very large percentage of all whistleblower awards are for $5 million or less. So I think the outsized portion of whistleblower, cases that result from whistleblowers ultimately result in relatively smaller dollar recoveries. So, and I don't know what the share of kind of, if you take the huge cases, most of the biggest monetary remedy cases that the SEC pursues are FCPA violations. And I think it's knowable, but I don't know what percentage of those are attributable to whistleblowers.
Right. I think that's a very interesting observation, that it's the foreign bribery cases that in many situations wind up actually leading to these big awards. Mary, I saw you shaking your head in the affirmative. A little bit of insight, a little bit of background, especially now that you're building an international practice. FCPA must be huge for you.
Yeah, I would say the majority of our whistleblower cases out of our London office come in the form of FCPA allegations. So absolutely. I mean, I think the reason we made as a firm a decision to put a flag in the ground in Europe, and London in particular, was that the Office of the Whistleblower issues annual reports to Congress, which we've all been citing to. And one of the things they record is the country of origin where the whistleblowers are coming from. if they're outside of the United States. And, there's something like 100+ countries that they come from, but year over year, the country that contributes the most tips to the SEC is the United Kingdom, with the exception of Canada creeping ahead, and they were tied with Germany this year. But, we have about 10 years worth of data. And that certainly has been the case that, since putting our flag out, there have been lots of international whistleblowers, not just in the UK, but, globally, who are calling us about Foreign Corrupt Practices Act violations in the extractive industries and elsewhere.
Yeah, so in a certain sense, not a surprise that if you're in the business of bribing people, you want to keep that a secret. And if somebody knows about the bribe, then they have an incentive to blow the whistle. And people involved in the bribing business, I'll share a phrase I learned several years. They tend to be coin operated. And if you can wind up getting paid for turning someone in, especially if the SEC doesn't disclose your name. One of the things that people don't recognize is the SEC has a legal obligation to maintain as confidential the identity of whistleblowers if the whistleblower comes to the SEC through an attorney, right, Mary?
That is absolutely correct.
Which is one of your selling points, isn't it, Mary?
I'll let you say them for me. It's better coming out of your mouth than mine.
No, that's exactly right. And the other thing that's really interesting about the information equilibrium that's generated over here, as Steve pointed out, is that the SEC has learned that if high quality whistleblower attorneys are representing a whistleblower who comes to the agency, that's a signal that you should take this information seriously, because you, Mary, don't want to waste your time with somebody who's a tipster that isn't going to lead anywhere, because you wind up getting paid only if the tip is a good one and the SEC is able to collect large amounts of money. Is that right?
That's absolutely right. I mean, we're a contingency fee lawyer, so we, our interests are aligned with our clients, that we only want to bring something that's successful. But I think one thing you haven't mentioned is that our reputation in the office really matters as well, right? We're repeat filers, so it's very important that we only bring cases that we vetted and that we really fully stand behind. So yes.
No, I think that's exactly right. Steve and Mary, let me ask you this question. If you look out over the horizon, say 2 or 3 years, how much growth do you expect to see in this phenomenon of whistleblowers coming in with quality information? And what percentage of the SEC's deal flow do you think is going to wind up being generated by whistleblowers?
So, I think it's hard to predict. I mean, I don't think anybody could have predicted I think the number of whistleblower tips this past year was up 30% over the previous high. And I don't think anybody could have predicted that. I think it may be, COVID related in some respect. And I think people have speculated for, as to the reasons why. Look, I think the large number of awards and the high value of some of those awards can only serve to incentivize, additional whistleblowers to come forward. I also think that there's a knock-on effect in that there is probably more industry self-reporting in the face of a successful whistleblower program than there is without it. I think when industry identifies a problem, one of the things they're thinking about is, am I going to be beat to the SEC by a whistleblower and lose the opportunity to win self-reporting credit? That's obviously, I think lots of institutions resolve those, competing concerns differently. But at least I observed anecdotally, more self-reporting in the kinds of cases that, we're likely to have perhaps a whistleblower involved.
So Steve, I think you're exactly right, that this whistleblower mechanism sets up what we law professors like to call a prisoner's dilemma type situation, where you're actually in a race. The whistleblower winds up getting the award only if they're the first person in with original information. If a company self-reports to the SEC before the whistleblower gets to the SEC, then the whistleblower gets nothing. Right, Mary?
Yeah, I mean, I think one thing that we need to clarify, though, that is what makes the whistleblower program in the SEC unique is that they actually welcome multiple whistleblowers. So you do have to, the first one in, you're right, Joe, the first one in with original information precludes all others as to that information. But if you, and we have many clients who do, come in with information that is different than the original whistleblower gave them, including, interestingly, we've now seen a whistleblower award announced from the SEC to a whistleblower who basically wasn't showing a securities violation necessarily, but helped with the location of the assets for asset recovery. So there are multiple ways that whistleblower, and there can be multiple whistleblowers. But yes, it's always a race to the courthouse. You always want to be the first in the door with the best information to cover the landscape. That's absolutely right. But it doesn't necessarily mean that you couldn't later on come in with something else that's different. But absolutely, you want to be first.
But Mary, as you and I know, you want to be first because that's where you get the big check. All right. Now, the other thing that's really important is, as a practical matter, if the company realizes it's got a problem, and if the company goes to the SEC, picks up the phone, Steve, hey, look, we just discovered this terrible bribery situation in country X. We've been paying the prime minister buckets of money. All right. Here it is. Please record all of this sort of stuff. And then the whistleblower shows up 5 minutes later. Whistleblower's out of luck. Is that right? Steve?
Yeah, I think there's probably some nuance in that. And, you know, the whistleblower can add information even if they're not the original reporter. But, you know, as a general matter, you know, if the SEC knows about something and opens an investigation and a whistleblower shows up after that happens to, you know, provide a tip to the same thing, the whistleblower doesn't get credit because they haven't advanced the investigation.
Now, this is really important, I think, in terms of the economics and the dynamics of Mary's business, of what Rob is involved in, of the stuff that I do, because what it does is it makes everybody pay attention to the clock. All right. You know about information. A whistleblower comes to you, Mary, you're going to want to put together the best file you can as quickly as possible, because you don't want to take 6 months to develop the information and somebody else beats you to it, the company self-reports. Is that right?
That's absolutely right. And I should add that one thing that we'll touch on, I know when we talk to Rob, is that the SEC has basically incentive to whistleblowers to not delay. So if you report internally first, you get a plus in that discretion of the 10 to 30%. So I think that's really important. That's just another reason we want to show that the whistleblower isn't sitting on his or her rights, waiting for this to metastasize and get bigger, that we want to come in quickly to show that we're not delaying.
Yeah, Rob, so from within the corporation itself, what do you see as the evolving pressures and incentives that force corporations to relate differently to their employees, force them to relate differently to their regulators? How is this changing corporate conduct?
Yeah, well, Joe, in the old days, people used to say that, integrity is doing the right thing even when no one's watching. I think today everybody's watching everything, right? And there are no secrets anymore. When you're the general counsel of a company, I think you have to understand that, in the old days when I was growing up, there were 3 news stations. Today, everybody is their own news station. Everybody's got their own newspaper in the form of a blog, and everybody's got their own camera crew following them around everywhere. And here's their camera. And everyone has a worldwide audience when it comes to being able to spread information. You can't assume that something's going to remain quiet anymore. So the path forward, if you're a company, in my mind, is you got to commit to the path of operating with integrity and with transparency. And I think you have to understand that, despite these big awards, and despite the story you told up front about, somebody wants to grow up to be a whistleblower because of all the money involved. A lot of whistleblowers don't want to be whistleblowers. We've got Erica here who can describe it, better than I can. But a lot of whistleblowers only become whistleblowers when they've tried to do something inside the company, and they've been ignored. They've been pushed aside and nothing's happened. So look, if as a general counsel, as someone, as a leader in a company, I've got to assume everything is going to become public. I've got to create an environment inside the company where people are comfortable coming forward and bringing this information forward so we can deal with these problems inside the company as much as possible before it blows up into something that can define and wreck a brand and careers.
No, I think that's exactly right. And the incentives of whistleblowers are really a fascinating phenomenon. And I think, Erica, you've got a perspective that in many ways is virtually unique. Could you share with us a bit about your personal story, your experience with Theranos, why you came forward, particularly the way you did, and then expand a little bit on what you've learned about other whistleblowers and their motives and incentives?
Yeah, definitely. So I'm sure majority of the people in the audience are familiar with the Theranos case, but I'll just give its sort of one-liner. So Theranos was a blood diagnostic company in the Silicon Valley that essentially was raving about this new technology that they created to do all your blood diagnostics in a finger stick versus a venous draw. But come to find out that technology never really existed. And even the, I would say, MVP product that they had of this sort of blood testing unit was deeply flawed. But they still decided to use this deeply flawed product on patients early without their knowledge and consent, and basically resulted out tens of thousands of patient results with unreliable tests. So I had kind of come into this company as a lab associate. I was the lowest of the totem pole. This was my first job out of university, and was really in charge of validating this technology to see, does it work or not? Is it good and safe to test on patients? And once we kind of felt that it was, then integrated it into a clinical setting where we could scale out, instead of just testing maybe 1 or 2 patients or just research participants, maybe testing 2,000 patients a day. And my kind of role within the company was really seeing the fact that when I was running these experiments as a lab associate, they weren't working. Everything and all the evidence, all the experiments I was running were telling me that the technology was faulty. We were producing inaccurate and unreliable results. A lot of untrained staff was in charge of really highly complicated processes. There was a ton of fear and silencing and firing, frankly, that would go on whenever anyone would come forward to sort of say, hey, I think we need to pull the brakes on this. We're launching this technology too soon, and it's not safe. We could really harm the lives of so many people. I think everyone now has sort of a crash course, sadly, in diagnostics of, if you have a faulty test, the implications that that could have. For example, if you have an inaccurate COVID test, this could mean you get a false negative, you go back home to your family, your whole family gets sick when you had anticipated that you were safe. So this is the gravity of this particular case. And after really trying to report internally, reporting to my supervisor, because again, lowest totem pole. So my supervisor, the vice president, the COO of the company, and I'd even gone to one of the board members' house to try and plead with him that what he was being told was not actually what was happening behind closed doors, was kind of just told, you seem smart, but I don't think you know what you're talking about. Maybe you should work somewhere else, or you aren't sort of qualified to make these calls. So after kind of hitting so much resistance, I felt personally very uncomfortable with being told that I needed to process patient samples at all cost with this technology that I fundamentally didn't believe in and I thought was inaccurate. Left the company, and then got approached by a Wall Street Journal reporter who said that he also had heard kind of similar claims from other employees that the technology wasn't working. So this sort of interaction had triggered me talking to a lawyer who had basically revealed to me that I could report to a regulatory agency. And in the blood diagnostic world, to get a company to stop processing patient samples, it's not the FDA because they are in charge of the distribution of medical devices. It's actually the Center of Medicaid and Medi-Cal Services, and specifically the CLIA amendment. And they're able to basically tell you, can you process patient samples or can you not? So I filed a complaint with CLIA. They conducted an investigation, and luckily that investigation was found that what I was claiming was true, that there were a lot of deficiencies within the laboratory. They were putting patients at risk, and they were barred from testing patient samples from that point forward. So that was the kind of journey, I would say, to reporting. Like Rob had alluded, I really am kind of one of these unintentional whistleblowers. It was never my intention to whistleblow in the first place. I didn't even really call myself a whistleblower until the media started calling me a whistleblower when I finally was on the record. So it was sort of a bizarre, a new concept to me. The intention was really to stop them from processing patient samples. I had no intention. If I could go back in time and have a reality where the company decided to basically pull their technology, stop processing patient samples, work on the technology, and maybe, the claims were so outlandish in the Theranos case, it would have never come to quite that fruition, but some level, some vestige of success to provide more accessible and affordable diagnostics for people, I would take that avenue, 100%. But unfortunately, that wasn't the reality of the situation. And what ended up happening was that this company really needed to have regulators come in and tell them to stop, because they weren't going to do that on their own volition. I think it's interesting to me to hear Joe say that people are now claiming that what they want to be is a whistleblower when they grow up, because it's not a really
Not a happy-
straightforward journey
Yeah.
at all. And I think there's of course the struggle of the process of whistleblowing, the fact that you have a lot of social rejection. You have people telling you like you're not being a team player. When in my case, I really wanted this thing to succeed. So that's always hard to sort of constantly have hard conversations with people and them not believe you when you're telling them that there's a problem. I think for me personally, it was very challenging just because the retaliation that I had received from Theranos, specifically the fact that before the Wall Street Journal articles came out, before the investigation that CLIA had conducted had really kind of pushed all the way forward, they were threatening to sue me. They were hiring private investigators to follow me and intimidate me and to make me frightened and to make me scared. And they did. They did. It was incredibly painful. You had David Boies, who at the time was, the top corporate lawyer in the United States, that was coming in and saying, if I don't comply with this list of demands, that they're going to face litigation towards me. And I was 23, I believe, 23, 24 at that point, had probably, no money to my name, no prestige to my name. No one, as many people in even investors have told me, and even Sunny, the COO of the company, I was fairly a nobody. No one knew who I was because I didn't come from any sort of prestigious background or anything like that. So it was incredibly stressful to have to figure out so young, how do you manage the situation of just trying to get them to stop engaging in the behavior of processing patient samples with faulty technology. And I think the incentives and the awards are great, but honestly, going through the process, that's so little of what you're thinking about. It wasn't even on my, it's still not even on my radar to this day. I'd never received a whistleblower award. I never applied for one. You just really, I think in my case, was in a position to say, I have this insider knowledge and I don't know if I can live with myself knowing what I know in allowing this company to continue doing what they're doing, because it has such clear consequences to people. And just as I expect people to respect, respect me or the, if I were to go to the doctor with my sister and came out of there and realized that the doctor botched all her lab testing, I'd be furious. I'd lose my mind. I would go absolutely insane on that doctor. And to realize that there were so many other people that same occurrence was probably happening to was probably the biggest motivator to me to like push through what was a fairly challenging process to make sure it happened.
Well, Erica, personally, I just really very much want to thank you for everything that you've done. I think it's a great social benefit. It came at a tremendous personal cost to you. The amount of bravery and courage that you had to exhibit, basically being at the bottom of the totem pole and standing up to people like David Boies, suggests to me that you're a very special person. And I just wish there were more people in the world like you who could stand up and basically protect the rest of us.
Yeah.
These kinds of situations, in my experience, are toxic. And they're not only bad for the company's employees, the investors, but in your situation, they did medical harm to people. And those are among the worst of all conceivable situations. So, look, all I can tell you personally is thank you very much. You're obviously a very, very special person, and we need more people like you. So
Yeah,
flat out. There's no other way to put it. Thank you.
Yeah, that's the hope, right? If you share, even though it was a fairly painful experience, and sometimes it can be painful even to share it, that just like, bad ideas or antisocial behavior can be contagious. Let's try and see by sharing these stories, sharing these narratives, sharing the moments where people did stand up and do the right thing, even when it may have been challenging or come at a personal cost, that can be just as contagious.
Yeah.
That, if for the people who are leaders of organizations, that they can realize that.
So Mary, Bob, can you just take a few moments and sort of expand on the dark side of being the whistleblower? I opened it up a little bit jokey with, I'm getting phone calls from people who want to grow up and be whistleblowers, and we look at the financial rewards, which now, can run over $100 million. But there are people whose lives are, in effect, destroyed by coming forward and being whistleblowers. Bob, Mary, you want to share any insights about that?
I'm happy to share. I've spent 25 years now representing whistleblowers. And it's funny, Joe, I think one of the things I learned early on is that you need to be more than a lawyer in these cases. You need to, once you've evaluated their claim and you say, okay, you've got a viable claim, you really need to take your lawyer hat off and say, but should you bring it? Are you in a position? And then you really have to describe to them the parade of horribles that can ensue. So I think, I've experienced, the worst in my career is I lost a whistleblower who actually died. There are whistleblowers who've been poisoned. I mean, all of these things seem really far-fetched, but they're not. The bigger the target you're taking on, sometimes the more extreme the cases can be. So I think that really, I echo Erica's point, which is that most of my whistleblowers are not motivated by the money, but the money provides for them, and they don't even know they're a whistleblower. I have lots of, Tyler Schultz is one of our clients. He did not know about the program, but the purpose of the program, and he has filed, and we do represent him on an SEC whistleblower case. Why we worked with him was because of, the trade secret and the Protect TRO against him. His parents were mortgaging their house. Like, the money that a whistleblower reward provided could help him weather those situations. So I think, there's a marvelous book by a gentleman named Tom Muller who last year wrote a book called Crisis of Conscience: Whistleblowing in an Age of Fraud. And he describes whistleblower rewards as a one-time lump sum payment for the loss of a career.
I think in many situations it's entirely accurate, and with any luck, that's not going to be Erica's situation. But there are people who are, later in life and have a set of skills which really make them useful only in one career, or most strongly in one career. And after they blow the whistle at one employer, they're basically blackballed from the entire industry. Bob, any perspectives on the experience of whistleblowers and what corporations can do, basically, so that to me, maybe the most chilling experience was Erica does the right thing, goes to see a board of director, a member of the board, and she gets dismissed by someone who should have enough sense to say, I've got to investigate this. To me, that was so disappointing. Bob, any views, any perspectives?
Yeah, listening to Erica talks, it gives me chills. The kind of courage that it takes for somebody in her position to come forward is striking. And I would always want to work with someone like Erica, a reluctant whistleblower, but someone who has the courage to come forward at great personal risk to talk about a problem inside of a company. And I think, you want leaders at companies that welcome transparency. You want leaders who want to know if something is off with their product. They want to know if there's misbehavior, if there are issues in the place, because there's no such thing as a problem that you know about that you can fix. The real problems are the ones that bite you that you never hear about. So for me, great leadership is about creating a culture where whistleblowing would never be necessary, because employees feel comfortable to raise their hand and say, I've got a question. I see something that bothers me. I'm not sure this is right. And I think those are companies that are built for the long run. And those are companies where, principled whistleblowing will never become an issue because employees are comfortable speaking up. And that's what leadership, that's what, in my mind, leadership is responsible for creating at a company. But unfortunately, that's not the way that all leaders act. And you have certainly some leaders that are more motivated by fame or by money, and they want to charge ahead and they want to ignore the problems because it doesn't fit with their narrative of the success that they are so bent on achieving in the short run. So, yeah, I mean, it's a lot to think about when you join a company. What kind of a company are you joining? What's the makeup of the leader, and what motivates them when they get up to work every day? That plays such a huge role. I was speaking to a whistleblower the other day, and just remarkable the parallels with what Erica talked about. A young woman right out of college, first job, large company, gets in to the most junior person on a team and starts seeing things that she couldn't believe, and they didn't seem right. Goes home, tells her husband tells her she's crazy. Goes and tells her parents say you're crazy. What you don't know? And the whistleblower I spoke to on her own quit the job at this large company against the advice of everybody in the family because she couldn't, in principle, go to work anymore and do it. And what happens? 2 months later, the entire thing blows up on a major public company. And now everyone sees that she was the hero and was the one that had the principles. But I think it's a real path of courage to take, and often one that's lonely. So hearing Erica's story, I admire it, and I love to work with somebody like that at any company. And I think good companies would want people like that.
Couldn't agree more. But let's also look at the dark side of the moon. All right.
So I was just I was reflecting on the comment you opened with, which is someone who said they wanted to grow up to be a whistleblower, and it seems like actually kind of one of the silliest statements I've ever heard. And particularly if you're thinking about it from a naked sort of financial calculus, it's a really awkward and imperfect system because there are so many variables out of the control of a whistleblower about whether that person receives an award and how much of an award they receive, right? So just to tick a few of them off. So you're a whistleblower, you could be beaten to the door by your employer or another whistleblower. That's one, disqualifying you. Two, your case might be assigned to an investigator who never is able to successfully pursue the case. You're out of luck. Three, they successfully pursue the case, but the entities are bankrupt or judgment proof by the time the investigation is complete and no money is recovered and you get an empty award because there isn't a recovery. Or the chance is that the entity that you're blowing the whistle on isn't a large financial institution or a large public company, and it just doesn't result in a very big recovery. And in any event, the SEC's investigations took last year on average 21 months on average. And complicated ones often take longer. And then there's a process for adjudicating the award. So even if you saw a payday, it could be way down the road. So it just seems like a kind of, I get that like large awards and a frequency of awards incentivize whistleblowing, but if that's the way you want to make a living, it's probably better off to get an hourly job. You're going to end up with a more likely uncertain recovery.
Let me assure you, the person who called me up and said, how do I go up to be a whistleblower, was somebody who was well steeped in all of the information you just shared, Steve. And what they were focusing on is the very powerful incentive effect that one award in excess of $100 million is going to have on some people to come forward. Right? My prediction very simply is that the importance of the whistleblowing program to the SEC's intake is going to increase very substantially, all right, over the next 2 or 3 years. And what we have is a spiral effect, all right, that you give out a large award, you get more information, you give out more awards, and this is going to expand. Before we go to questions, what I'd like to do is I'm unaware of any phenomenon that doesn't have a dark side. Okay, everything has a dark side. And there is a dark side to whistleblowing. And I've seen it in situations where, for example, an employee is going to be terminated. All right. And the employee says, well, you're going to let me go. I'm going to blow the whistle on you and I'm going to get some leverage in the termination situation. And I've seen situations where corporations have a complaint come in and everybody knows it's nonsense. All right. Unlike Erica's situation. All right, this is a situation where responsible people, fully aware of everything, they know that it's nonsense, but the corporation still has to spend 7 figures doing an internal investigation, investigating everything, and there you go. You've got to respond to the whistleblower. You can't ignore the whistleblower in today's world. And whistleblowers know that by making up stories, and I've seen that happen, just total nonsense, you can cause the corporation to spend millions of dollars investigating, and you can negotiate a settlement and say, okay, fine, pay me this, and you don't have to pay the lawyers, and away we go. Any views about that? Steve, Bob, Mary?
Yeah, I mean, look, there are obviously, people who are whistleblowers like Erica who are altruistically minded, right? And motivated by all the things that, when we think about what is a whistleblower, you encapsulate, Erica. And then there are people with, more nakedly commercial motivations. And then there are people whose motivations are evil, right? I mean, there are people who claim whistleblower status to protect themselves from adverse job action. And that's causes a big cost and drain for some of the reasons that you talked about, Joe. And the reality is it's just a cost of the program. One of the there are very strong anti-retaliation provisions in the whistleblower statute that protect whistleblowers from job retaliation. I think one of the most curious things I saw over the last few years was the Digital Realty case, which was a case that was decided by the Supreme Court, in which the Supreme Court said to take advantage of the anti-retaliation provisions to be a whistleblower protected from retaliation, you can't just report internally. You have to report, to the commission. And I found it most surprising because that was one of those I was always raised to be long-term greedy, not short-term greedy. And that seemed like, a company pursuing that case to the Supreme Court, was kind of a short-term greedy thing. They may have won that particular case, but they've created a structure in which whistleblowers are now driven to report to the SEC. And that's another cost.
Out of frying pan into the fire, but in terms of the Supreme Court's decision, if you recognize the court is very textualist, That was a very easy decision to predict.
Yeah, I just am surprised that industry allowed that decision to be pursued. But look, the reality is, I don't think there's any, I can't think of a solution to, prevent this phenomenon, unless you were gonna, try to, punish non-meritorious whistleblowers. And I don't think there's any incentive or appetite for such a.
So, just for the sake of transparency and accuracy with regard to everybody that's listening to this program, I think we need to recognize Erica is just absolutely spectacular, but Erica is on one end of the spectrum. Not every whistleblower is like Erica, and at the other end of the spectrum, very unfortunately, we do have whistleblowers who come forward, concoct information, and they do it so that they're protected as whistleblowers, and so that they have an argument that they shouldn't be terminated, or they have an argument for compensation in the event that they are terminated. And when you're in the real world long enough, you wind up seeing everything. You wind up seeing great people like Erica. You wind up seeing not so great people who basically use the whistleblower mechanism as a form of blackmail and threat. And that also winds up happening.
Can I just quickly comment that I just want to make clear that while I agree that those are both ends of the spectrum, I honestly think, and I know that the False Claims Act, in fact, their founding fathers said it takes a rogue to catch a rogue. And that's why that I think the motives of a whistleblower should be irrelevant. And I think that it's really important, as long as their information can be corroborated, we should not care. And in fact, some of the worst frauds involve people who are compromised individuals to begin with. So I just want to sort of add that approach, that I don't want to see us ever coming to an approach where we're looking. And I know that actually has happened in some of the UK laws where they're looking at motivation. They finally have gotten rid of it, but I wouldn't want to move to that place.
No, Mary, I agree with you. I'm not saying anything about motivation. I am saying things about fabrication. And the simple reality is, if you have an employee who comes forward with a fabricated story, that employee can easily cause a corporation to spend millions of dollars on defense. And the corporation is not going to be able to turn around and say to the employee, okay, you had no foundation for coming forward with all of this stuff. We spent $8 million investigating. Give us the $8 million. That's not going to happen.
And Joe, I've seen,
yeah,
I've seen this. I've seen people who, are in the process of being managed out of a company, suddenly coming up with a claim that no merit, and very clear to me that their motivations were not pure. I agree with Mary that their intent shouldn't matter, but if it's not meritorious, that's simply another matter. And look, you got to make a decision. You may need to spend millions of dollars in order to thoroughly investigate their claims. And by the way, I think that there's value in this. Look, as a leader in a company or as a general counsel, you don't want to believe these things, right? So you might be looking at it with a bias of, this can't be true, this is ridiculous. And something like this, the whistleblower laws force you to take it seriously and force you to take a close look.
Mm-hmm.
And that, I think that's healthy. But sure, there's frustration in companies when you get these claims that are obviously fabricated for purposes of gaining leverage in an employment situation. I unfortunately think that's a cost of doing business and a cost of getting the value out of these sorts of laws.
Before we turn to Q&A from the audience, let me just open it up to each one of the panelists that we have and ask each of you, what's the major message that you want to share with people that are listening to this session? Steve, what's the big takeaway that you think people should have about the whistleblower program? What's the one big?
Yeah, I think you've alluded to it, Joe, which is, this is a program, whether you believe in it or not, it doesn't really much matter, because it's here to stay, and it's a significant force that is going to be relied on by regulators, and is going to incentivize reporting, and is going to affect the calculus of the way industry responds to the discovery of potential misconduct. And I just think it's it's like arguing about the weather, right? I mean, it sort of doesn't much matter, right? It is here. And I think people just need to grapple with it. And, I believe that the best strategy for corporations who face, are the subject of whistleblower claims is to treat those whistleblowers carefully. Being dismissive of whistleblowers, is a very, very risky strategy.
Mary, what's your one big idea that people should walk away?
So obviously, I think the SEC program is a game changer. It has shown itself to be this sort of the gold standard of whistleblower reward programs. In fact, it has motivated the creation, even within the United States, of additional reward programs. The Department of Transportation program for an auto safety program was inspired by the SEC's success, and so has indeed the new, as of January 4th, the new anti-money laundering whistleblower program within the Department of Transportation. It's also inspired the Ontario Securities Commission to adopt a copycat, and across the world, other folks are looking. So I do think that, it's a terrific program, and the changes that have come with the amendment have both goods and bad sides to them. But what they have done in terms of the efficiency of processing more claims has really given more faith in whistleblowers that, this isn't just a lottery ticket, that more people will actually be receiving rewards if we process more quickly and handled more expeditiously. So I think that what I would leave folks with is that the trend of whistleblower reward programs expanding both within the United States and internationally.
Rob, what's the big message you want people to walk away with?
Leaders have to take responsibility for driving integrity into the culture of their company. And that, look, as a leader, you are creating a culture. And if you're doing it poorly, you're not only breeding bad incentives and the potential for bad behavior, but you may also be breeding a culture that encourages whistleblowers who are frustrated by a lack of transparency and frustrated by a feeling that no one cares. So really, as a leader, you need to invest both in creating a culture of doing the right thing and following the law, but also creating a culture of transparency where people can raise their hand without fear.
Erica, I think it's only right, just, and proper that we give you the final word.
Yeah, thanks, Joe. I think a big takeaway is for people to understand that when someone's trying to have a difficult conversation with you, to understand that it's just as hard to say something as it is sometimes to listen to something. And in the case of majority of these whistleblowers, it is the case that they probably do care about the company that they're working for. They do care about the organizations that they're a part of and the people that they're working with. And understand that even though it's hard to listen and to really understand what it is that they're trying to communicate to you, that it's important for all of us to kind of get better at understanding that there may be things that people tell us that are difficult because they threaten our position, they threaten our expectations, they'll make us lose money, lose time. And it will be generally something that will seem to come at a price, but in the long run, it'll be more rewarding. And so I hope a big takeaway for that, for people in this, is to kind of understand that in the context of people who decide to speak up.
And again, thank you very much. Kristen, you have Q&A for all of us, I hope.
I do. Thank you. All right. So how many whistleblowers come from the private sector versus the public sector, if you have that breakdown, and what is the difference between those whistleblowers? And that's probably best directed at Mary or Steve.
So I'm happy to jump in here on that one. So under the SEC program, there aren't public whistleblowers. So one of the things that I'm actually critical of, and we've seen it a lot with the Trump whistleblower, the phenomenon of the numbers of Trump whistleblowers, is that there is a huge disconnect, that we don't reward government whistleblowers, yet we only reward folks in the financial sector. I think that needs to change because it's equally as important, the information that they're bringing forward. But just to be clear to the people in the audience, the SEC doesn't only handles companies traded on U.S. stock exchanges or otherwise. at private companies like Theranos, but it doesn't deal with government employee whistleblowers. There's a marvelous group called the Government Accountability Project that supports those whistleblowers. That's a nonprofit group, but it doesn't have a place, unfortunately, with the SEC.
How can whistleblowers work around confidentiality agreements or NDAs or things of that nature?
So there is a provision of the rules promulgated under the whistleblower statute that prohibits companies from putting clauses in agreements that muzzle whistleblowers. I'm blanking on the rule number 17A something or other, but the SEC has actually brought a number of enforcement cases against companies who put such clauses into such non-disclosure clauses into separation agreements. And I think most of industry has figured out that, this is not something that is permissible to do. Those, to the extent there is a clause that says, you can't talk to the SEC or the government without, first giving notice, to the extent that's inconsistent with, the whistleblower program, those types of clauses, I think, are typically unenforceable.
Yeah, and Erica will remind us all that whether they're unenforceable or not, corporations try to use them to scare people, because when you're 22 years old and your first job, you don't know about SEC Rule 17A3-B sub 6J. You just don't know. Can a lawyer intimidate you and say, you signed this agreement that says you can't do that? Oh, yeah. Easy.
Okay. A lot of whistleblowers report internally before going to the SEC. So what are companies doing wrong, and what can they do better to make sure that those complaints don't actually end up with the SEC?
Well, I mean, one thing the companies need to do is they need to make sure that they're really putting out a welcome mat for these complaints. In other words, I talk to people at companies who tell me, oh, Rob, I don't think we've got any real issues. We've got a hotline, it's anonymous, and we never get any complaints. And I respond, well, that's actually probably the first sign of a problem, right? Because there are issues. There are ethical questions and issues that come up every day at the company. And too often people don't use the hotline because they're afraid to become a whistleblower. People like Erica don't want to go to legal. They don't want to go to HR. They don't want to have to use the hotline. You got to make people feel comfortable to raise these sorts of things. And so, when I was at Airbnb, we had a number of programs that were designed to sort of take the fear out, where you didn't have to go to a lawyer. You could if you wanted to, and of course the hotline's there, but we want to make it more of a, you're doing the right thing for the company by speaking up if you see something wrong and creating that kind of an environment.
I think we need to focus on the human dynamics here. In many situations, when a whistleblower comes forward and says, look, we've got this problem, if you take the problem seriously, you're ending somebody else's career. All right, that's the reality. So you wind up going and you're reporting to the general counsel, whoever it is, and it then acquires sort of a salience that's different from, here's the problem that's giving rise to the whistleblower complaint. It becomes very interpersonal. It becomes very human transactional. If we go forward with Erica's complaint, well, then Elizabeth Holmes' career is done. We can't listen to Erica and save Elizabeth at the same time. It's one or the other. And again, here I am playing amateur shrink. And it's when I see these dynamics play out and they implicate loyalties. All right. I've been loyal to this person. I know them for a long time. If I believe the newcomer, then I have to throw my friend under the bus. I'm not going to do that. Therefore, I'm not going to listen to the newcomer. It's very often this kind of psychology and emotion that winds up getting the better of the objective facts. And if I'm often amazed, disturbed, whatever the word is, trying to explain some of the patterns that I see. And I think it's this aspect of human nature that often winds up explaining patterns that are otherwise almost inexplicable.
Kristen, if I may just echo too, I think that there needs to be a cultural change within organizations where they actually reconceive the notion of what a whistleblower is. And instead of seeing them as snitches and disloyal, no one wants to hear, shoot the messenger. We need to reconceive them as canaries in the coal mine who are actually probably your best early warning system, early indicators of risk. They're actually your most valuable employees. And there's some really important research that came out of George Washington University's Graduate Business School and out of the University of Utah that I love to say, because it's something I've known intuitively, is that whistleblowers are the CEO's best friend. And this research basically says that companies that have internal reporting hotlines, just like Rob said, that are ringing off the hook are actually the healthiest, because they can deal with the situations as they come in. People are trusting the organization to report, and they can, avoid. So they basically drew a direct line between active hotlines and smaller settlements, fewer government investigations, smaller settlements and employment claims, fewer claims. So I think people really need to internalize and not be scared by the whistleblower reward programs that, again, internalize the myth is that, they're just going to skip and go straight to the regulator, despite the fact that Digital Realty says you should. 80% of the whistleblowers who go to the SEC program reported internally first. Most of my clients do that. They want to help you. They don't want to sideline their career. They've spent a long time training to be in this position. So I would just say, listen to them and change how you think about them. When you're looking at performance evaluations, why don't you put something in there that's a category on whistleblowing, speaking up, asking the tough questions?
Good point. And to follow up on that with another question here, what are the best actions a board member can take if they become aware, for example, through a whistleblower, that there is a problem? And can all board members be sued, or do they have any protections in such reporting?
All right, as a board member, I'm happy to address that. Number one, if somebody comes to you with a complaint, and this has happened, the first thing you do is you pick up the telephone, you call your general counsel. You give your general counsel all of the information that you have, all right, that's related to it. And you don't just walk away from it, you sit on it, and you make sure that the general counsel is responding appropriately. As a practical matter, the probability that there'll be any liability for a director that behaves that way is, I would describe as extraordinarily low, a fraction of 1%. The worst thing you can do is hide from the problem. All right, the worst thing you can do is make the determination yourself as a director that this person deserves no respect, and this makes absolutely no sense. In many situations, here's the smart thing to do. Now, here it's the only thing to do. All right, you can't sit on it. You've got to share with general counsel, and you can't just leave it alone. You've got to follow up. And you've got to make sure that the GC's response is appropriate.
Right. What do you anticipate seeing in the Biden administration in terms of the number of whistleblowers and protections for retaliation?
Steve?
Yeah, I mean, I don't think that, that you're going to see seismic rule change. There's a robust, program in place at the SEC, staffed by people that are, supportive of the program. And the program is designed to pay whistleblowers. I don't think if you look at the results of the program, I don't think that there has been there's been some criticism from the plaintiffs' bar about, new rules that were promulgated. But I don't think that, a fair reading of the record suggests that the last administration has been, hostile to whistleblowers. I think that actually, the data suggests the opposite.
Yeah, in fact, I'll go even farther. What I'll say is that under Steve, and Stephanie, the mechanism has already been put in place where you're going to get this spiraling effect. I think Mary agreed that as soon as you get these large awards and people know that the rewards are coming relatively sooner, the incentive to come forward and to try to get these awards is going to increase. It's simple econ 101. So what will happen is, under the new Biden SEC, you're going to see more whistleblowers coming forward. and you're going to see more awards, right? And people will say, see, look, the Biden administration is doing something much more, effective than happened under Jay Clayton, to which my response is going to be, guys, you've got to worry about causality. You've got to worry about the analytic quality of your thought here, because this mechanism of action was really put in place under the Clayton SEC, and it's now playing out later, all right, under the Gensler SEC. But Gensler's going to get credit for it, even though it was Steve that started it. That's okay. That's life.
Okay. This will be the last question too, because I know we're running out of time here. Would the SEC be more efficient if it proactively alerted the market to specific kinds of high value information it wants, similar to what is done by the CFTC?
Bonus points. Mary?
So, one thing I want to say that I do want to commend the CFTC. When you ask about are whistleblowers valuable to government enforcement agencies, I have anecdotal evidence, but it's actually confirmed on their website. The CFTC does more than the SEC. They actually go out to conferences and set up trade show booths. So I went to the International Derivatives Expo in London, and I went and saw their trade show booth, and they were giving out whistles with lanyards with the phone number on it, mouse pads, complimentary bags, all of it. So I think the CFTC does a lot of things that maybe the SEC doesn't do.
So I did not. So is it like an international spoofers conference where all the spoofers show up and you turn in the spoof?
You can go on their website and you'll see where they're presenting at all the key conferences where they expect to see, talk to educate potential whistleblowers. And of course, I always joke that, can I set up the trade show booth right next door to yours?
No, even Mary, what you should do is you should sponsor them. What you should say is, no, I will pay for you. All right. And then you're just there and you're just taking pictures of everybody who comes up there. Then you can just give them the business card. You'd be great.
I can tell you, I did interview as sort of a cub reporter. I interviewed some of the attendees and asked them what did they think about this booth, and they said that they walk really far away from it as they cross the conference room floor. But I don't think I answered the exact question. I know, Steve. Why don't you take the
Yeah, my all I can say to this is that my counterpart at the CFTC, Jamie McDonald, who was the enforcement director, has joined our law firm as of last week. And so I'll have a chat with him tomorrow about this, giving out freebies to get whistleblower tips.
That's great. Well, thank you so much to all of the speakers, and thank you to everyone in the audience for joining us today and for your great questions. I hope you can join us at our upcoming morning program, which is on February 10th. The topic will be evaluating ESG risks, opportunities, and challenges in the M&A context. All right, thanks everyone. Have a great afternoon.
Thank you.